Hi. This is the third episode of our talks about dispute resolution in California. In this episode, our guests Antonio Valla and Lisa Shockney from San Francisco, California, will share their views on mediation. They'll explain what is mediation and how it works, why many cases get settled in mediation, and how to draft in mediation clauses in contracts as a first step before jurisdiction or arbitration. Make sure you follow Legalmondo on LinkedIn and YouTube to stay updated on the next episodes.
Hi, Lisa and Antonio. So, welcome to our third episode of Dispute Resolution Talks, discussing California. In our previous chats, we've been talking about state court and federal court, and then arbitration. And it's time to discuss about mediation, starting from what it is and give us some background. Maybe, Lisa, you can start here.
Thank you, Roberto, and it's good to see you again. Many people are familiar with mediation. It's utilized worldwide. It's very common in Europe and becoming more common, particularly in the Scandinavian countries. In the US, mediation is really used as a dispute resolution procedure in the course of litigation, in the course of a lawsuit. And what it is a procedure where a neutral third party helps the parties to the mediation reach a jointly acceptable resolution. It tends to have a structure that ordinary negotiations between parties or counsel lacks, and it is really controlled by the parties. Even though there are specific guidelines that some mediators follow, the parties have the ultimate control over what mediation is. And there's a few common principles that happen in mediation. So the parties usually choose the mediator. So the parties may have greater trust in who they choose because it ultimately is their choice. Mediation is not binding. It's not binding unless the parties come to an agreement. Usually that agreement is memorialized in writing. And then if they do come to that agreement would be binding, assuming they agree to do so. The most important feature, I think, of mediation is that it's confidential, both in terms of what's discussed at mediation and what the ultimate agreement says. This is an advantage because a case, a lawsuit is public. And so the information that's disclosed, trial, all of that is public knowledge. And so is a verdict if it's reached. In mediation, the parties can actually freely discuss things and even really admit to things that cannot be later used against them. And that helps the parties reach a resolution because they're able to talk more freely without the fear that something would be used against them later. Finally, there is really no right versus wrong in mediation like there is in the course of a lawsuit. Everybody always thinks they're right, the other person's wrong. I mean, that's the reality of what litigation is. But in mediation, there really is no right and wrong. You're trying to find some middle ground between the parties, and usually that middle ground means that nobody's really that happy in the end, but that can resolve the case without then having to have a public resolution in front of a judge where someone is really told whether or not they're right or wrong.
Okay, thank you. Antonio, I'm wondering how common is mediation in dispute resolution in the USA?
Essentially, it happens in each and every case. I mean, I think of mediation as supervised negotiation. You have an adult in the room who's the mediator, who you've jointly selected, most likely you're jointly paying. Typically is a retired judge. I like retired judges because they bring a lot of experience to the conversation, and not so much vis-a-vis the lawyers, but vis-a-vis the clients, the companies involved, they tend to bring a certain gravitas. It is one thing to have a lawyer tell you, look, you're right or you're wrong. It's an entirely different thing to have a retired judge tell you the same thing. So I tend to select judges unless the case is extremely complex, technical, in which case it's a mediator who may not be a lawyer, but who has deep technical knowledge. Say there's a dispute over the functioning of a particular sophisticated machine, then he or she can bring their technical experience to bear in the negotiation. Mediation pretty much happens, I'll say it, happens in every single case, whether it's private mediation or it's imposed by the court through a court supervised system. It really happens all the time, and it's a vehicle for settlement. The vast majority of US civil cases, I think well in excess of 90%, settle before trial, and mediation is the big meat grinder. They put you through it, and you put yourself through it, and you hope that your case will settle. As Lisa mentioned, the hallmark of a good settlement is that everyone is a little bit dissatisfied. No one is happy. And that's how typically it works in mediation. My experience is that after mediation is concluded, however, a few days after, a few weeks after, you talk to the clients, and the clients are actually happy. They realize that the process that they were going through was expensive and inefficient and uncertain. And mediation brings a degree of certainty, because if it leads to a settlement, then you know you're going to pay X or you're not going to pay X, or whatever the resolution is, but you have resolved the case. It's important that the mediator be neutral, that he or she not have any connection to any of the parties, and unless, again, it's a technical mediation, that he or she not have any connection to a particular industry involved. Mediation has become an industry in itself in the United States. I believe there are tens of thousands of mediators available through the arbitral chambers, so through the American Arbitration Association, or JAMS, or ADR systems. Those guys all have both mediation and arbitration. One more thing that I would like to leave you with is that often mediation is built into contracts, so that before you can go to court or before you can go to arbitration, the parties must attempt to mediate. And pre-trial, pre-litigation mediation is a great tool. Before everybody has spent a boatload of money on litigation, it is a good idea to see whether things can be worked out. You can do it contractually, you can do it voluntarily, you can even do it in stages. We are dealing currently with a situation where the contract specifies that there will be a senior management meeting at which they will try to fix the problem. And if that is unsuccessful, then they'll go to mediation. And if that is unsuccessful, then they'll go to arbitration. So contracts where big numbers are at stake, complicated performance is required, those are excellent candidates for a mediation clause, in addition to the arbitration clause.
Okay. Well, Lisa, are there other forms of mediation that are not private?
Yes, there are. Antonio briefly mentioned there's court-imposed mediation, which is technically not private mediation. The reason why it's not private is that oftentimes the court actually chooses the mediator for the parties. It's usually on some approved list, or the parties choose from an approved list. These mediators are often, these mediations are free to the parties. And so the mediators are sometimes not as qualified, because the good mediators want to charge the parties money. So the mediations are not always as successful because of those reasons, but the parties have no choice. They have to attend, and they may not be attending in good faith as well, because they're being forced to do something they don't want to do. That's different than private mediation, where the parties agree and they want to attend. There's also something called a mandatory settlement conference, a little bit different than mediation. This is during the course of a lawsuit, the judge will require the parties to have a settlement conference with another judge. So not the judge who is presiding over the particular case, but a judge that's entirely unrelated. These types of conferences usually happen right before trial. So because of that, they're largely unsuccessful because the parties have already spent the money, they've prepared, they've already gone through and still have not been able to settle the case. So the fact that they're going to something that's required doesn't always work out in the end. I've had one or two mandatory settlement conferences actually, but other than that, most of my other cases they're not successful in terms of public mediation, court-ordered mediation, and mandatory settlement conferences.
We can say that the system and the consequences of voluntary versus mandatory mediation are quite similar in my experience also in Italy. So, Antonio, let's wrap up this conversation with a takeaway.
I think the key takeaway is that mediation is something that you will encounter in US litigation. It's inescapable. And it's worth approaching it in the best possible way. The parties and their lawyers need to go into mediation in good faith with the intention of trying to settle the case. It is also very important to remember, should be mentioned, that in cases in which insurance is involved, it is fundamental that the insurance representatives, the insurance adjusters, participate in the mediation. And it's fundamental that before the mediation, the insured and its lawyer and the insurance adjuster meet privately and define what good faith means, so that everybody goes into the mediation with the right set of expectations, including the expectation of lowering the risk, lowering the cost, and ultimately avoiding trial.
Okay, thank you. And that was a very good tip at the end. So thanks a lot. And I'll talk soon on the fourth episode of this dispute resolution series in California. Goodbye.